Members, once again, welcome to today's lecture, and it is about introduction to business law, and the class is NCBA 2-1. Last time we had covered some topics, and today we are continuing with where we stopped. Today we shall look at the definition. Majorly we shall look at the law of contract, and as far as the contract is concerned for today's lecture, we shall look at the definition and nature of contract. Then we shall define a contract. We shall look at the different types of contracts. We shall look at the essential elements of a valid contract. And then let me first define a contract, and we proceed with other subtopics. A contract is generally defined as a legally binding agreement that exists between two or more parties to do or abstain from performing certain acts. And these parties can either be natural persons or artificial persons. Me and you can be called natural persons, and an artificial person can be like a company. A contract is a bargain, a tit for tat, a deal from which all parties are expected to benefit. So all the parties to the contract should actually get mutual benefit out of it. And for the benefit of simplifying a contract, it must be a legally binding agreement. All contracts are agreements, but not all agreements are contracts. Because the contract must be binding, meaning all the parties to it must be able to fulfill their contractual obligations. Failure to do so, an aggrieved party has a right to sue for damages. So it has, in the definition, you cannot ignore a legally binding agreement, and it exists between two or more parties. There cannot be a contract if the party is just one person. There should be two or more parties. And as I've said, these parties can either be natural persons like me and you, or artificial persons. For instance, a company. A company can enter into a legally binding contract with another company. That's why we call a company or an organization, we call them artificial persons. Now let us look at the different types of contracts. Contracts can be classified into the following types. The first type is called express contract. An express contract is a type of contract in which the parties specifically agree about the nature and the terms of their relationship, either orally or in writing. That means when you enter into that type of contract called express, either you agree with another party by the word of mouth, that is orally, or you have to write and you put it into writing. So it is where the parties specifically agree to the nature and the terms of the contract orally or in writing. Once that one is done, then we call it express contract. Then we have implied contract as another type. This is where the terms of the contract are ascertained from the conduct of the parties and the surrounding circumstance. Here, there is nothing like oral or written. Just by the conduct of the parties, you tell that they have entered into a binding contract. Then another type, we have specialty contracts. Specialty contracts are also called contracts under seal. What does it mean? This actually means that a specialty contract has to undergo some formalities And these formalities include, they must be written, they must be sealed, and they must be delivered. So a contract which is written, sealed, and then delivered is what you call specialty contract, otherwise also called contracts under seal. And a good example of such contracts is a deed, for instance, the partnership deed that we looked at last time. Another type is called valid contract. A valid contract is a type of a contract with all the essential elements of a valid contract. And these elements include offer, acceptance, consideration, form, capacity to contract, free consent. Therefore, if a contract has all the essentials, then it is called a valid contract. And a valid contract is a type of contract which is recognized by the courts of law. Then we have another type of contract called simple contract. A simple contract is also called the paro contract. This is a type of contract which does not need to be in any specific form. It can be in any form of a contract as already mentioned above. That is, it can either be written, it can be oral, or it can be implied by conduct. Then we have another type of contract called void contracts. A void contract is a contract which is not allowed and accepted by courts of law. It is not enforceable by courts of law. That means if you enter into a void contract, it has no legal effect on the parties. In short, it does not exist. It comes from the word void, null and void. For instance, if one enters a contract with another party out of mistake, out of fraud, misrepresentation, illegality, then that contract is called a void contract. Then we have voidable contract. This is a type of contract which is enforceable at the option of one party, meaning if there are two parties, the terms of the contract are binding on only one party. For instance, if an individual enters into a contract with a minor, that means the contract would be binding on the major, on the adult. It can't bind on the minor. That is avoidable. It is enforceable only at the option of one party, not two parties. But two parties have entered into that contract, but the terms will not bind another party, like a minor entering into a contract with a major. Then we have bilateral contract. Bilateral, bi means two. That means the terms of the contract, if it is bilateral, binding on two parties. Then for unilateral, that means the terms of the contracts are binding on one party. Then we have illegal contracts. Illegal contracts, these are contracts prohibited by law. They are contracts prohibited by law, they are against public policy, and they are not enforceable by courts of law. Once you enter into an illegal contract, then you can even be prosecuted by courts of law. That means you have committed a crime. As we already saw that for a crime to be complete, that there must be two elements, mens rea and actus reus. So all people who enter into a contract, an illegal contract, it means they have committed an offense, and therefore it is advisable for people not to enter into illegal contracts. Illegal contracts are prohibited by law. For instance, a contract to steal, to murder, to rape, etc. Another type of contract is called executed contract. An executed contract is a type of contract where both parties have performed their obligations and nothing remains to be done. That means the parties to the contract have already fulfilled their contractual obligations. They have done all what they are supposed to do, and there is nothing left to be done. After they have finished their contract, then we say it is an executed contract. On the other hand, executed contract is where both parties have performed some obligations, but there still remains something to be done. That means they haven't finished what they are supposed to be doing. Then we have contracts of record. These are contracts which consists court judgments meaning that there are contracts which, after the parties have entered into, actually it is the courts of law to make them formal. We call them contracts of record. They consist of the judgments of courts. The rights and obligations of the parties are determined by the courts of law. Then we have contract uberrima fidei. That is a Latin word, which means that one of the parties to the contract has the material facts and must disclose them to his counterpart. It is like you are going to enter into a contract and someone knows each and every detail of the contract, but another party doesn't know. Now another party should also know, so at the end of the day, he does not claim that he didn't know what he entered into. And in law, we say, if you are above 18 and you have entered into a contract, then you can't change your mind. That's why we call it the doctrine of caveat emptor. So contract uberrima fidei, one of the parties has the facts and must disclose them or must inform the other part about the facts before he or she enters into a contract. Now let us look at another subtopic called essential elements of a valid contract. For the contract to be valid, it must contain the following essentials or characteristics. The first one is called offer. Obviously, before a party enters into a contract, something must be offered. That's why you say offer refers to expression of willingness. And for a contract to be valid, then there must be expression of willingness. Both parties must be willing to offer something. Then another one is called acceptance. Acceptance is the manifestation by the offeree of his or her willingness to the terms of the offer. Once something has been offered, then the party is willing to receive, then we say it is a valid contract. But if you offer something and the other party rejects it, then there is no contract. Then that contract is not valid. But with a valid contract, there must be something offered, then the other party accepts it. Then we have consideration as another element of a valid contract. Consideration is the price paid by one party for the promise of the other. An agreement is valid, is legal and legally enforceable by law when both parties to it give something and expect something, which we also call tit for tat. You give and you get. So there must be a mutual benefit. And as we shall see later, there are different types of consideration: past, executory, and executed. But something must be given to a party, and another party also expects benefit, so that both parties at the end of the day get mutual benefit. Another element of a valid contract is called capacity of parties. Parties to the contract must have contractual capacity. That means they must have capacity to contract. There are parties or there are persons without the contractual capacity. And once they contract, then it cannot be a valid contract. For a valid contract, parties must be above 18 years, must be of sober mind, and they must not be under the influence of drugs and alcohol. Therefore, minors, lunatics, or mad people, alcoholics cannot enter into a valid contract. Then we have another element called the free consent. Free consent, both parties to the contract must have consensus of their mind. They must agree without being forced to enter into a contract. For the contract to be valid, there must not be an element of any force anywhere. Parties must enter out of their free will. Free consent, in Latin we call it consensus ad idem. Then we have another element of a valid contract called intention to create legal obligation. This is where the courts must be satisfied that the parties intend that the agreement they are going to enter into is legally binding. And that's when the court will take notes of it. Therefore, for a contract to be valid, any subject matter entered into by the parties must be legally binding. Then possibility of performance. What does it mean as an essential element of a valid contract? That for a contract to be valid, the subject matter must, whatever the parties have entered into, should be something that can be possibly done. The parties should not enter into something which is difficult to do, but the subject matter must be, there must be a possibility of performing what you have entered into. For instance, if you have decided to construct a building, the construction of a building is something that can be done. But you cannot enter into a contract of manufacturing firearms, well knowing that manufacturing of firearms in Uganda is a preserve of the government, not individuals. That means that the contract you have entered into is not valid. Then we have another element of a valid contract called form. Some types of contracts must be prescribed in a certain form for them to be valid. For instance, like a partnership deed has to be in a specific form. Therefore, there are some types of contracts which must be in a certain form. Failure to be in that form, the contracts cease to be valid. Another example here is a specialty contract, which must be written, sealed, and delivered. Failure to write and seal, then deliver it, then the contract ceases to be a valid contract. Now, members, I'm just giving an introduction about the law contract, but I want also to talk briefly about the assessment, the mode of assessment. You will be given a test, and the test will be done online. You will do fortnight quizzes, and I will mark them out of 40 using online. And the examination is still pending till the reopening of institutions by government, while the final examination will be done out of 60. And I encourage all the members to join this class so that you really, at the end of the day, we can do wonders. Otherwise, I wish you the best. Yeah.